Strange game. The only winning move is not to play.
Hello there, how are you doing? Hope you're well. I am still at home. Feel like I will be at home for the foreseeable future. Hong Kong is in lockdown pretty much, and it feels like we're partying like it's 2020 even though it's 2022. So we're going, it's not back to the future, is it? We're just back in the past, which isn't quite as exciting, even though I often get very excited about time travel. But I'm not here to talk about time travel this week. I'm going to talk about disputes. Now, disputes is the sexy part of law in the view of many people. Lots of people, when they imagine a lawyer, is someone, particularly if they're in a jurisdiction where you wear gowns, in a gown, possibly even with a wig, shouting objection across a courtroom where people gasp in astonishment as some amazing piece of evidence is discovered. And let's face it, if you watch lawyers on TV, most of the time they're doing dispute-related work. It's very rare that you watch an interesting TV drama or movie even in terms of contract negotiations. We have Judge Judy, but we don't have contract negotiator Judy. And certainly you wouldn't have had Jack Nicholson shouting, "You can't handle the truth," when he's talking about a data privacy clause in a contract. I might do that in my next data privacy negotiation. We will see. But anyway, bit of a history of me, very brief. Long before I was doing technology law, I spent a brief period just doing litigation work and a bit of arbitration work too, but I was a disputes lawyer. I trained as a disputes lawyer before I did any contracts or drafted any contracts or anything along those lines, and I carried that with me. So my work tends to be split about 50-50 between contracts, cool, funky new technology things that are happening, which is what I get very excited about and what I normally talk about here, but then the other half tends to be arguing when something goes wrong. And that could be a dispute over a contractual clause. It could be that a technology system that was delivered didn't work as it was supposed to. That tends to be the most common thing. It could be disputes over data privacy breaches. It could be literally anything. Non-payment disputes were huge in 2020 when people were really struggling, for example. And it's very common that things do end in dispute. I often feel that when people enter into a contract that they don't really think about how it might end. I assume it's a bit like when people go on their first date and they're all very excited about things, think this is going to be great. They don't get to the point where people are separating their belongings and throwing people outside of apartments or things like that, which tends to happen in quite a lot of contracts. Not all contracts go successfully, and the ones that don't can be very messy. So you end up in a dispute. And when you have a dispute, you rely on a couple of things. Assuming you've got a contract at all, and I would hope that you would, you rely on your dispute resolution clause and your jurisdiction clause. Your jurisdiction clause is quite simple. It states which laws of which jurisdiction apply to your contract and therefore to your dispute. So if you enter into a contract with someone, do you want that to be governed by Hong Kong law? You maybe if you're in Hong Kong. Do you want it to be governed by Chinese law? Maybe again if you're in Hong Kong, who knows? Do you want to be covered by a law of the US? Do you want an obscure law that no one's ever heard of? I once was involved in something where people hadn't updated a contract template they'd gotten off the internet. For some reason their contracts were subject to the laws of Iran, which is a bit of a surprise in that they were a major organisation. Thankfully they were easily able to change it because nobody wanted to be subject to the laws of Iran, but it could have been a big dispute. I've seen massive arguments over whether laws are subject to Chinese law or Hong Kong law. It's something that happens quite a lot in this part of the world. The legal systems are very different. They completely different principles behind them. You've got a common law system versus a civil law system, for example, so it's very important. So you've got that. The other thing that people often forget about, particularly in international contracts, is what language any dispute will be conducted in. We'll come on to that in a bit more detail in a second. Now, when you read a contract, if you're someone who's excited about a new deal, you're probably looking at the payment clauses. You're probably thinking, how much money we're going to make out of this? How cool is this project going to be? But if you are a lawyer, pretty much like me, or I would say any other lawyers, but particularly dispute lawyers, you're going to look at the back. You're going to say, so what happens if this goes wrong? What is the jurisdiction I just spoke about? Where would people be having to fight their battle? Would it be in a jurisdiction I know and I can act in? Would it be somewhere else? You'd be looking at what the things are that you have to do before you go to a dispute. Would you have to negotiate first? Is the requirement to get chief executives into a room to bash heads against each other with a view to saving some money on a dispute? All of these things are very important. But the dispute resolution clause will also specify not just the jurisdiction, not just hopefully the language the dispute would be in. This has become quite relevant, particularly when you're in international work. I must keep saying that. But they also say what mechanism of dispute resolution you use. Now, I've used a lot. I've done plenty of court litigation in jurisdictions across the world. How exciting is that? I've also done lots of arbitrations. I'm going to focus on court litigation and arbitration for the purpose of this. We also have something called mediation, which isn't really a way of deciding a dispute. It's the way of trying to get people to agree, basically to stop what they're doing, stop fighting and come to some sort of settlement. There are things like expert determination, which is a little bit like arbitration, but an expert decides, and it can be binding or non-binding. All sorts of exciting things you can do in terms of, sadly, there's no trial by fire where people shoot each other, and no trial by sword as far as I'm aware, at least not in Hong Kong. But the two things are very different, and they're both very important. And the thing is, one I feel is more suited to technology matters than others, and one is perhaps more suited to international disputes than the others. So litigation, if you've watched any courtroom dramas, you'll know what it's like. Your courts are essentially provided by the state of the country that your jurisdiction is in. So if you go to Hong Kong courts, the Hong Kong courts, they're not actually that far from where I live. You turn up, you essentially fight for any number of days before a judge who is not necessarily appointed by you. It would be very unusual if they were. They're just selected and they will decide the outcome. The court can be very rigid in terms of procedure. We have something here called the White Book, which governs procedure, but there are similar things all over the world. You have the CPR, the Civil Procedure Rules in the UK. They decide when you submit a claim, how you submit it, when you can respond, how you make a counterclaim, how you make offers to settle and whether they would be binding, and what the penalties are if you don't essentially beat that offer and you don't accept it. All of this stuff is contained in the Civil Procedure Rules. But the whole thing is there's a lack of control. You tend to lose control when you have a court procedures in your contract and when you go to court. Now, on the flip side, going to court is relatively, I'm not saying it's cheap, it's relatively cheap. You don't have to pay the judge, is the main thing. You will pay some money to start a claim, you will pay some money in terms of how the claim is monitored, but it's a fraction of what you would pay, for example, you went to arbitration. Of course, the judge is free. The issue is you don't pay the judge, you don't get to select the judge may not be an expert in the topic that you are actually discussing before him or her or whatever. It may find that actually you've got a big complicated technology matter and your judge normally does family disputes, and which means that you can try and convince them what the outcome is, and they will use expert witnesses which you will have to pay for and will be very expensive, will try and give some advice and try and sway things whichever way, but ultimately the judge may not have any clue what the subject matter is about. Technology cases are well known. They're much better now, but certainly when I was at university studying law, there are lots of cases of very old crusty judges. This is in the UK. I don't seem to remember anything about this. So how exactly does this MP3 work? It's not quite so bad now, but there is an issue that you don't have an expert in place. So it can be a little bit of a crapshoot. But hey, it doesn't cost very much, and it's much easier to do in terms of procedure. You go to court, that's it. There's a clear body who will decide what happens. So court's pretty cool. I like going to court. I like going to court in Hong Kong because often I get to wear a gown and I feel a bit like Batman. I like it because occasionally you get to say objection. You can say it in arbitration, but it feels like it's a bit more exciting in court. It's something that, again, is quite costly. Some places you'd have to use a barrister, for example, and Hong Kong is one of those, as indeed is England and Wales, but that will vary from place to place. But that's option number one. The other option, and the one that I think is probably better for international disputes where you're choosing between different jurisdictions, or indeed for anything that's a bit more technical or a bit more complicated, is arbitration. Now, arbitration, you do this at law school, you get taught this is litigation, this is arbitration. Arbitration is essentially where you agree with the other side, normally when you're drafting your contract, but you could agree to go arbitration later on, how a dispute will be resolved and by whom. Who selects the arbitrator, how many arbitrators you have, and what procedure you will have. Normally you will find, it's before 1 to 3 arbitrators. You could have more or less. Best to have an odd number though, just in case they don't agree on an outcome. Let's put that out there. But you'd also agree which arbitral body would manage the dispute. Now, what is an arbitral body? Arbitral body is essentially an organisation who handle the mechanism and how a dispute is run. They don't decide how the outcome of a dispute, but they have panels of arbitrators you can choose from. They decide how the procedure will be adhered to. They essentially are the organisers, the administrators, the people who make it happen. And there are loads. The ICC is probably one of the most famous. Everyone seems to know that one, and I'll give you what the abbreviations are by putting them up, otherwise I'll be saying too many words. In Hong Kong we have the HKIAC, we have SIAC in Singapore, we have CTAC in China, we also have SHIAC in Shanghai, if that one's relevant. These are all very, very important names to bear in mind, by the way, because they're all very different. LCIA is different in London, and you have separate ones for certain organisations. So you may find a professional body has its own arbitrator that you have to use. So you go to one of those, and they all have different rules. You need to make sure you know what the rules are. They will say how you start an arbitration, how you respond to an arbitration, what your deadlines are, how the arbitrator is selected, how you object to arbitrators, what happens if something goes wrong, how to make applications, and so on, and so on, and so on. All the rules will be slightly different. You need to know that. You can't just assume that one arbitral body is the same. Also, on top of that, all the rules, they may follow the same rough framework, but they can sometimes vary widely. They may have rules, for example, of what language the arbitration is in. You could have an instance, for example, where you assume you're going to arbitration in a jurisdiction only to discover that entire arbitration has to be done in a foreign language. So every single document you have needs to be translated, notarized. Every piece of evidence needs to be translated. Suddenly the costs go up. So that is really key. The plus point though, as I said, is you're more likely to get an expert. If you have an IP dispute, you choose an IP specialist as your arbitrator and you hope that you get the outcome that you may want. If you have a very complicated blockchain related dispute, you go to arbitration, get someone who's an expert in blockchain who's an arbitrator. There are some of them around, which is kind of cool. And they will hopefully come to the same conclusion that you want as well. But no guarantees. And that's the thing. With both court and with arbitration, there are no guarantees. It's essentially a crapshoot. You may think you've got the best case in the world, but you don't know that until you've actually presented it before essentially an independent body who will take a view. It may be you've got a witness who's not trustworthy. It may be that someone has lied to someone. It may be that someone is not what they seem. There was a brilliant case years ago, B-Sky B and EDS, which I recommend you read, where one of the witnesses was flat out lying and it brought down the entire case pretty much. But he went down in such a blaze of glory, well, not really glory, but he went down with such aplomb that it was just astonishing to see how bad it was. And yeah, just it involves getting fake degrees. It's worth reading. But the issue is you never know what the outcome is. So for me, if I'm drafting a technology contract, I will do a couple of things. First off, how much money do the parties have? If they don't really have much cash and they don't expect to, it may be that you have to go with court procedure and you have to go with litigation. But you make sure you choose a jurisdiction that both parties are happy with and a choice of law and indeed a language. You've always got to think about that. I would normally go that just because it's cheaper, but with the proviso that you may not get an expert judge. If there's money, if they're more sure that they can actually afford to go to an arbitration, that you won't find that the richer party just wins because they've got more resources to pay for an arbitration, the other one actually can't even afford lawyers anymore, then go for arbitration. Make sure you choose an arbitral body that you are familiar with the rules and you're happy with, and make sure that you can choose which arbitrators you want. Think about the fact you're paying for the arbitrator as well as your lawyers, and think about the cost. Arbitration generally, but not always, is more expensive than litigation because you're paying for the arbitrators, but both are by no means cheap. And my ultimate advice would be, if you are getting into a dispute, and this may be counterproductive given that I do disputes, if you're thinking of getting into a dispute, don't. Try and get out of it by any means necessary. Try and settle it, try and reach agreement. One of the strongest arguments I've ever seen was a mediator. This is an independent party who's trying to get people to settle, getting the parties to write on a board how much they thought that they would spend going to court. And neither party really had a very big number. Then he asked the lawyers to do the same thing, and they wrote down how much their fees would be, and the case settled the same day. You are spending a lot of money for something that is by no means certain. It's a bit like investing in NFTs, isn't it? But that's it for the moment. I hope that was useful. You'll see on my LinkedIn I have put a thing saying if anyone got any topics they'd like me to cover. If you want more dispute related stuff, I rarely talk about it. I'm more than happy to, just let me know. But anything that you find interesting, I'd be happy to do a video on. It will probably be from here, where I can move forwards and backwards in this new room that I'm in, this new setup. But I can't move from side to side because there are records all around my feet. But there we go. Anyway, that's it for the moment. Take care, and hopefully see you soon.